Welcome to the Equal Opportunity Commission's panel discussion on human rights and age discrimination. I am Dr. Godfrey St. Bernard. Today's discussion is centered on a topic that most persons may be familiar with: human rights and age discrimination in Trinidad and Tobago. In the studio with me are two people that share a passion for this topic. We have Mr. Haran Ramkaran Singh, the Director, Legal Services of the EOC of Trinidad and Tobago, where he leads a team of legal and investigating officers. Our second guest is Misty Ann Dorman Hossain, a member of the board of the Employers Consultative Association. I'd like to welcome both of you to this panel discussion. I'll first like to start with you, Mr. Ramkaran Singh. Yes. Could you give me a background of the commission, and as well, could you provide some information on the Equal Opportunity Act?
Yes. Well, the Equal Opportunity Commission is a public body. We were created by the Equal Opportunity Act of 2000. That act was passed to prohibit certain kinds of discrimination and to provide a mechanism for where members of the public who felt they were subjected to this kind of discrimination could lodge a complaint and can have, some sort of resolution. The Commission is mandated to receive and investigate complaints from members of the public. Upon investigating, we try to conciliate the matter, which is where you bring parties to the table for a discussion. If it cannot be resolved, the Equal Opportunity Act creates another institution called the tribunal, which is a court. And the unresolved complaint can be referred to that court for hearing and determination. Now, we are concerned with certain types of complaint. The Equal Opportunity Act applies to discrimination in 4 broad categories: employment, education, the provision of goods and services, and the provision of accommodation. However, that complaint of discrimination must be tied to certain what are called status grounds under the Act. The Act currently protects 6 status grounds: race, ethnicity, religion, marital status, disability, and geographical origin. So in other words, a complaint to the Equal Opportunity Commission should, for example, relate to discrimination in employment on the basis of your race, your ethnicity, your religion; discrimination in education under the same categories, on the basis of your geographical origin, on the basis of your marital status. One of the status grounds that is not covered under the Act is that of age. And the Equal Opportunity Commission, as part of its mandate, it has certain mandates under the Act, one of them being to make recommendations for amendments to the legislation, has recommended that age be included as a status ground for protection under the Act.
Could you also reflect on perhaps, some of the engagements with equal opportunity issues, not in the context of Trinidad and Tobago, but in other jurisdictions, perhaps in the Caribbean or elsewhere, that could provide some lessons for us here in Trinidad and Tobago?
Well, we are unique in the Caribbean region because there's no Commonwealth Caribbean, no English-speaking island that has a similar legislation. However, there are other countries in the world that have legislation, equal opportunity legislation. For example, England, over the years, they had started with different pieces of legislation: a Race Relations Act, a Disability Discrimination Act. In 2010, all of their legislation was consolidated into one piece, the Equality Act of 2010. Australia is a federal colony, or federal country, sorry, and each state in Australia, New South Wales, Victoria, Queensland, they have their own Equal Opportunities Act. There are also similar legislation in Hong Kong and in Canada. In the United States, there is the Civil Rights Act of 1964 and the Americans with Disabilities Act of 1992 that seek to give the same kind of protection as we have here.
Okay, Ms. Dorman Hossain, I want to turn to you now and ask you to give us some background on the Employers Consultative Association in terms of where you sit and this introduction or proposed introduction of age as a status ground for discrimination in the workplace and in other arenas?
First, I want to say that the ECA, of course, subscribes to and supports the mission of the EOC, and that we aspire towards the fair, just, and equal opportunity for all members of our society, including the grounds that currently exist and the ones that are to come. I mean, discrimination, we wish could be eradicated because it really eats away at the core of our humanness, if I could use that word. Now, historically, what we saw in the 70s and 80s were people in the ages over age 55 were leaving the workforce. And in the 90s, we saw a reversal of that trend where we saw persons over that age limit coming back into the workplace. And whether that was an issue of affordability or including longer tenure, longer and healthier lifespan, those dynamics continue to change, and we are seeing the persons in that age bracket continuing to be in the workplace. Now, specifically for employers, some of the issues that I think will arise relate to, of course, establishment, development, and implementation of policies and procedures that could protect employees and prevent discrimination in the workplace. And not just policies and procedures, but mechanisms to address grievances, complaints, and so on. If I may, I want to talk about age stereotyping a little bit. Currently, what we see happening in the workforce, persons close to retirement, or even just maybe older in age, may face challenges accessing training, promotions, even new employment, because of the view that if you're not going to stay in my workplace that long, then why am I investing training in you? We all know that training and development are costs and time for a business. Now, that means older employees could be overlooked for promotions and prevented from opportunities. Because it's felt that maybe, I can train a younger person who has more, if I may say, shelf life. Now, in terms of age stereotyping, employees don't come with a best before date, right? And we've heard of sexism, we've heard of racism, there's also ageism. But the reality is that there are views that older employees can be seen as not as productive. They may be more costly to the business in terms of benefit cost, higher salaries. They may have fitness for work challenges and absences. They may, not fit with the current trends in terms of being technologically savvy. You may even speculate, do they have the energy and drive to cope with the demands of a constantly fast-paced environment? And whether it's a misconception or not, we joke about our cognitive ability and that it declines with age. Our memory might fade, or it's harder to learn new things, change our ways. Almost like an analogy to depreciation of your assets, but not your equipment, but your human capital. And, there is evidence from the U.S. Department of Health Services that suggests that your brain, areas of your brain relating to learning and memory and other mental activities do decline. Notwithstanding, I've spoken at length about, some of those issues, stereotyping more mature employees. There's also younger employees who also face stereotypes. And they may, not be securing jobs because they may perceive, they're more mature employees in the workplace, and therefore that might prevent my ability to secure promotions. And, that will also influence succession planning for an organization. Of course, another big issue that we see as related to employers would be costs and how we manage those, because, like I said, benefits cost would be something significant. Typically now our plans don't provide for any benefits past retirement age or minimal benefits, and contemplating age and how that affects cost would be an issue. And also one of the bigger things is that we will have to undergo training for our employees, equality training. You'd have to train the workforce generally to accept the various generations. I think right now there are about 7 different generations in the workplace, the most we've ever seen. And training younger employees to work with and manage more mature individuals, as well as working our more mature individuals to manage under a more youthful or younger boss, as it seems. So those, I think, are some of the issues we would see coming out. I mean, there are also social implications when you think about some of those persons who may retire going into caregiving responsibilities for working parents.
Okay, you made a lot of references to the training dimension in a human resource management framework. But I'm also thinking that perhaps, I would like to have some sort of reflection from your perspective on other areas of human resource management from the standpoint of advertisement, from the standpoint of assessing performance with respect to hiring. Do you have any perspectives that you can share with respect to this amendment to the Equal Opportunity Act? Do you have anything that you can share there?
So certainly, and I mean, that's what I referenced when I said development of policies and procedures and mechanisms. I mean, something you may take for granted as simple as advertising for young, dynamic individuals. That would be a no-no because young implies age, obviously. Even persons being declined for positions because you say, the reason given is you wanted somebody more mature, for the role. So those kinds of policies and procedures are what employers would have to establish. And also specifically in terms of the acts, the proposals speak to legitimate reason. I guess from an employer's perspective, we would want some more depth as to what would constitute proper and legitimate reason for discrimination on the basis of age. I mean, we see many advantages, of course. Yes. If I have some statistics here in terms of UK estimates that there's going to be 13.5 million jobs in the next 10 years that are going to be available, but the population leaving school is only going to be 7 million. And in Trinidad and Tobago specifically, by 2025, persons over age 60 is going to increase by 5% of what it is now to 17.7%, and 30% by the year 2050. That's a significant population that you can access to. We know fertility rates are declining and our populations are aging. So how do we tap into that? As I said, that's a significant pool of resources. And so when I say there are benefits, we can tap into that bank of knowledge and depth of experience that population of staff can bring. I mean, notwithstanding the stereotypes I mentioned, there is evidence to suggest that more mature employees have lower absenteeism, reduced turnover, and better retention levels. And I can tell you from a learning perspective that one of the biggest challenges we face is readiness of employees for their roles. And tapping into that resource is a great forum for training, coaching, and mentoring your newer employees. And the learning curve is very steep nowadays. The demands from customers and the environments is very high. So this category of staff, this demographic can provide history and continuum for an organization. And I don't know if you all have seen the movie The Intern, but that was really nicely expressed there, where the workforce, all under age 30, brought in someone who was more mature, someone retired, a senior person, and the CEO, who was an entrepreneur of a startup company, felt this person could not add value to my organization, but turned out to be one of the best resources. So there are definitely benefits to be gained by accessing the fact that people are living longer and healthier lives and have that bank of experience. I think what we want to be sure we do is address some of the implications, like in terms of cost and setting up the mechanisms in place, because I also understand that we're looking at keeping the mandatory age of retirement whilst we introduce the status ground of age. So how do we socialize that in terms of being able to ensure we don't discriminate against our employees on the basis of age, but have those conversations that are relevant in business organizations?
Response from you, Mr. Ramkaran Singh, and it really treats with the question of the process by which complaints are brought to the EOC. Could you shed some light on that, and perhaps, how this new amendment that is proposed may impact upon that? In addition, I would also like to get a sense from you in terms of, the outcomes of these processes in terms of how successful are these complaints when made by those who are aggrieved?
Well, the legislation creates a process for lodging complaints. Members of the public who feel that they have been subjected to one of the forms of discrimination must lodge a complaint in writing. The complaint should be within 6 months of the alleged act. The Commission is mandated to investigate complaints. As part of our powers of investigation, we are empowered to send a notice to a respondent to provide information with respect to the complaint. So a person who has lodged a complaint, they would be called in for an interview or for a discussion with our staff. We have investigating officers whose job it is to process the intake. Based on that interview and based on the discussions and documents that may be submitted, we may then write to an employer or to a respondent, it's not just only employers, and ask that they provide certain responses to certain questions. We are empowered to give them a deadline. We realistically try to accommodate as much as possible in terms of the deadline. But if a party refuses or fails to comply with the notice, we are empowered under the legislation to file proceedings before the magistrate's court, where they can be summoned, and if they cannot give a reasonable excuse as to why they did not comply with the notice, then they could be fined by the magistrate, and the fines are actually quite hefty. It's $1,000 a day for an individual, or $5,000 a day for a corporation for every day that they have refused to comply. Yes. But we have had, unfortunately, we have had matters that have had to go down that route, but most of our matters, we do get responses in a timely manner. When we get a response, we would consider the response. We may discuss it with the complainant. That is the person who lodged the complaint. However, we are not attorneys or representatives of the complainant, so we do not take the response and give it to the person. But we would discuss it with them, and based on that discussion, we may have further questions for the respondent. In that case, we'll send us another notice, and the process would repeat. At some point, we would have to assess the matter. If we find that there was no evidence of discrimination under the Act, then we would have to write the complainant and say, well, we found no evidence of discrimination. Many matters that are lodged with us, we might find some evidence of perhaps some poor industrial relations practice, perhaps a breakdown in communication. So I'm speaking here in the context of employment. But it may not necessarily point to discrimination under the Act, because under the legislation, you have to point to one of the status grounds as your motivating factor. You have to be able to say that the treatment that I received was linked to or correlated to my race, my religion, my ethnicity, my sex, my marital status, my disability, my origin. So many times, if we don't find that link, we would have to write the person and say, well, we have investigated your matter, but unfortunately, we've not found this link to justify pursuing your matter further before the Commission. That person may, for example, decide if they want to take their matter to a trade union, if they want to use some other mechanism to resolve it. So that is if we terminate the matter. Our next recourse would be to bring the parties to the table for conciliation. And conciliation is a voluntary process where the parties can sit down. We have in-house mediators who are licensed with the Mediation Board of Trinidad and Tobago, and they would facilitate the process, but it is a voluntary process where the parties can discuss amongst themselves and perhaps come up with a resolution. If the matter cannot be resolved, or it has not been resolved, then the next step would be that the Commission is mandated to prepare a report into the matter. The report has to be published, it has to be sent to the parties, and made available for the public to come and view it. And if after that is done, the matter still remains unresolved, then the Commission would refer the matter to the Equal Opportunity Tribunal, which is, as I indicated before, they are a court, and they will hold a hearing into the matter, and they are governed by their own rules of practice, just as the High Court is. So that is a more formal process. Normally, the parties would have to, under the legislation, they can either represent themselves or they can be represented by an attorney at law. So it's the same as any process before any court, the magistrate's court or the High Court, as it were. We have had a number of matters being resolved at conciliation, But again, it is always to be remembered, that conciliation is voluntary, so that if, for example, the parties are not willing to see eye to eye or not willing to come to an agreement, there's nothing that we can do. We can't force the parties to agree or to settle.
Okay.
Yes, so that I think, I hope that brings some clarity into the process.
Okay.
Yes.
For both of you, I'm thinking that we are talking here about a new status ground, age, as a basis for gauging the extent to which there might be some form of discrimination in the workplace. But in reviewing some of the notes in preparation for this, this panel discussion, I noted that there were some exceptional grounds that prevail in terms of treating with age as a status ground for discrimination. Could you share some light on these grounds?
Yes, and I believe Misty did mention that, there were provisions for exceptions. Under the legislation, with respect to the existing status grounds, for example, there are provisions for exceptions. For example, although we speak about the Act prohibits discrimination on the basis of religion, there is an exception for churches in determining who should be, any religious order, not just a church, but any religious denomination under the legislation has a specific exception for determining who should be ordained as priests or ministers of religion. So that, for example, certain churches say that only men can access the clergy. Other religions say that you have to be of a certain caste or background to access religious training. So the Act, this is just one example, they have made specific exception for that. There's also an exception, while the Act treats for discrimination on the basis of education, on the ground of education, the Act specifically makes exception for the Concordat, for the agreement between the state and the denominational boards. So that when one provides, these are just examples to show that although we provide against discrimination on certain grounds, certain status grounds, sometimes there might be justified reasons having regard to national and local concerns, international and national concerns. There might be justified reasons why you may say that perhaps we want to make an exception for that. Now, with respect to age, for example, let us say we just have age as a blanket ground. Then, for example, a person who is told that you have to be 16 years old to get a driver's license might say, well, I'm being discriminated on the basis of my age because I'm being told I can't, if I'm under the age of 16, I can't get a driver's license. Or that I have to be 21 years and over to, for example, to get a firearms license. These are genuine decisions where, for example, age would be a relevant factor, because you certainly don't want the licensing office to be giving driver's license to 12-year-olds and 13-year-olds. So that when we speak of age, for example, we do have to think about other considerations. There may be considerations where age would be a relevant determining factor. In the United Kingdom, they have certain tests known as the test of reasonableness and proportionality. That is to say that if you are saying that you would like to use age as a factor, you must show that it must be reasonable and it must be justifiable, having regard to the to the benefit of society. Another example, if you say that you have programs to assist young persons in finding work, and there are lots of programs out there, the ODT program, the YTEP, the MUST program, and those programs may tend to have a certain cutoff age. Then because of the social benefits to those programs, you may want to say that perhaps we should retain those programs with a cutoff age, because the thinking behind those programs is that you're trying to help recent graduates, young persons now coming into the workforce to adjust to find a job. And considerations will be different if you're dealing with, say, a 40-year-old or a 50-year-old person. So that so that there are a number of areas and areas and facets of life where you may want to say that age should be a relevant factor. Again, for the protective services, like for example the police force and the defense force, they say that you have, at a certain age you may have to retire from the police service unless you've risen into the ranks of the higher levels like inspector and deputy commissioner and what have you. But at certain ranks you would have to retire if you're over the age of 50, because realistically, you may not want to have a person who is, say, 65 years old fighting a war in the defense force or trying to run on a criminal, on the streets. So that there may be areas where you would have to look at age as a relevant factor. But that said, although we say it may be a relevant factor, at the same time, I don't think there's, there is a controversy about just picking an arbitrary age. I mean, why is it, for example, are you fit to be a police constable or police corporal at the age of 49, but as soon as you've reached the age of 50, you're now being told that you're unfit? what the Equal Opportunity Act seeks to do is create a society that is free from these sorts of artificial barriers, where persons are treated with on the basis of their merit and their ability. So even in a situation that I've just thrown out to you about officers, say in the police force or the defense force, I don't see why you have to have an artificial barrier saying at the age of 50 you must retire, if it is you're still fit and competent to do the job. So this is something that, again, perhaps employers would need to look at. How do you assess an officer's, or any person's fitness and competency, as opposed to merely saying, well, you know, you've reached the age of 60 and it's time for you to go, or the age of 50 or 40, as the case might be.
Okay, well, I think, you know, time is closing in on us, and we have to begin to wrap up. So what I'd like to get from both of you are some concluding remarks in terms of your hopes and aspirations with respect to what are likely to be some benefits and what are likely to be some of the challenges associated with this particular legislation that is proposed.
Yes. Well, I think one of the largest challenges that I see would be, again, making provisions for what should be reasonable exceptions. Ms. T, for example, did mention the concept of the mandatory retirement age. And while this is a reality in many organizations, including in the public sector, I think we would have to have further discussion on must we necessarily provide for a mandatory retirement age? Because as Ms. T quite rightly pointed out, there are so many benefits that older persons can bring into the organization. For example, if you tell a person who's now 60 years old that they have to leave, especially more so in the public sector, there's no succession planning. You know, they leave, and many times, for example, you try to access some goods or service from a public body, and they tell you, well, so-and-so is retired, and, you know, or worse yet, they've gone on pre-retirement leave for about a year and a half, and, you know, you're therefore, you know, lost in trying to figure out what to do. So I think this is one of the biggest challenges. We would have to think about whether or not we should make an exception for a mandatory retirement age, or whether we should move away from that. But it's something that requires more discussion.
Okay.
And from our perspective, you know, the ECA is committed to ensuring that our membership consistently complies with local and international standards. We want to endorse the Commission's recommendation that provision should be made to protect proper and legitimate age-based decisions.
Okay.
I'm happy to hear that some of those things are being contemplated, but, you know, I think just to emphasize that I want us to be sure we contemplate those implications, because they do have far-reaching implications for society and for other issues, like we mentioned. We spoke about cost. Also, the issue of differences in treatment on grounds of age shall not constitute discrimination if within the context of the national law they are objectively and reasonably justified, and I'm quoting from the proposals. And for employers, we just, you know, want to ensure that we make some more definition around that, you know, so that we can determine what's objective and reasonable in those circumstances. But, you know, if I may summarize by two quotes I heard, that we are not limited by age, we are liberated by it.
Okay.
And for the unlearned, old age is winter, but for the learned, it's the season of harvest. So, you know, let's not undervalue our harvest, and perhaps we'll be richer in our lives generally and in our corporate lives as well.
Okay, I'd like to thank you very much for your contribution to this panel discussion. That's all we have for today. Stay tuned for part 2 of this program, where we would have the EOC and the National Insurance Board of Trinidad and Tobago. Thanks for watching. I am Dr. Godfrey St. Bernard. Until next time.